Hi, everyone. Mike Vanoy, Vice President of Marketing at Assure. And today we're going to talk about seasonal employment. So here we are, end of May. Students are getting out of school. Some are taking finals this week, maybe finishing up finals in this next couple of weeks. And it has a fundamental impact on the labor market because we have this concept of seasonal employment. And I think we're going to talk about what is seasonal employment from a legal perspective, and in fact, is there such a thing? But it really presents new challenges to employers. I'd say especially small businesses and growing companies who take advantage of this new influx into the labor market without really maybe understanding some of the legal ramifications and some of the protected nature of whether it's based on age or hours worked and schedules. If your normal business runs on X number of employees that are kind of 40 hours a week, and they're all out of high school, they're 18 and above. They're things that you just might not think about in the day-to-day. So to help me unpack this topic today, regular guest to the show, Brian Shenker. Brian comes from Jackson Lewis, where Brian has extensive experience representing clients in wage and hour and really anything labor disputes, representing against maybe employees, former employees who sue, or actions taken by government, federal, state agencies against the employer, and can really help us navigate these, what is probably more complex waters than many of us would think. So welcome, Brian.
Thanks, Mike. Thanks for having me today. And yeah, certainly a very timely topic as we're headed into the summer season. I think, seasonal employment, it might change by industry, but I think we generally have, two time periods a year when seasonal employment becomes an issue for employers. And right now during the summer months, and then potentially right during the winter, holiday season. So
Right.
happy to jump into this today.
Yeah, so let's maybe just start out with a definition, right? So we talk on the show, we talk about exempt versus non-exempt, W-2 versus 1099, different legal classifications of employees. Is there such a thing as a legal classification as a seasonal worker?
So not necessarily. In various laws, especially maybe our local or state laws governing certain time off or sick leave, they might reference seasonal employment. But when we're talking about it, I think what we're really talking about is the temporary engagement of workers for anywhere from say 3 or 6 months. So I think it's usually on the shorter end there. And so, these employees are often hired to manage, increased workloads, for whatever reason. And, these employees, these seasonal workers, they might be working, full time, 40 plus hours a week during that period, or they could just be, simply part time, working, 20 or so hours. So it really ranges, I think, what these employees are doing, how they're assisting companies. But the main point is that they're temporary, that they're brought in for and right now we're talking about the summer period, and I think that brings many challenges. What we'll talk about today, many of the laws are the same for year-round employees and seasonal workers.
Yeah.
But when we're talking about the seasonal workers, I think there are lots of intricacies that we see applying to them that don't always come up with our full-time year-round workers. So it's important to be aware of those.
Yeah, I'll just kind of jump into it from a legal perspective, and don't encroach in your world. You're going to educate us here, but I think about the Fair Labor Standards Act. Do I have it right, Brian? I think it's 1928, right? I mean, this has been around nearly 100 years,
right?
And it established the first overtime rules, child labor protection laws. So you couldn't have a sweatshop filled with kids, right? And so I think so many times we think, you know, FLSA, even if a small business and employers are aware of it, it just feels like this old thing that you just don't realize, well, hey, wait a minute, school's out, I'm hiring a high school kid, maybe this is a 17-year-old. Am I even aware of what the Fair Labor Standards Act requires of me or does not allow me to do as an employer and make requests of these employees? So can you kind of take us through the high level here?
Sure. So obviously the FLSA, the Fair Labor Standards Act, that's what governs at the federal level, minimum wage and overtime, and especially nowadays with the very active plaintiffs bar and the state and federal labor departments, unpaid wages, paying people compliantly is at the forefront of what we're looking at.
Yeah.
I can tell you from my experience with employers that they often look at seasonal workers as while it's not classified like this under law, they look at it as more of an informal type of employment relationship. So, I've had audits where, it comes out that, while a company is keeping track of time and, pay records for all their other employees, their year-round employees, they just have decided not to do that, for their seasonal workers, either not tracking their time or simply deciding to pay them on some other basis that's not necessarily permitted by law. And I think that really goes to the mindset of many employers thinking that these seasonal workers are not subject to the same laws. And that's simply not the case, right? So when we're talking about the FLSA, that's a very important law to be aware of. One of the main things that it requires is, the federal minimum wage. Again, many states are above that. So you need to know what your jurisdiction requires. But overtime, many seasonal workers are working overtime because they're specifically brought in during a busy season and, hours may be long. And, one thing I often see is companies trying to, contract around the FLSA, right? Where the employer will say, I have an agreement or a policy or maybe even the offer letter stating, that the employee agrees to, work for $500 an hour, not an hour, that would be great, a week, and that, that covers all overtime work. And the law does not allow that. The FLSA is not something that an employee can agree to give up any of their rights under it. So, employers need to understand that there's still a formal employment relationship with these seasonal workers. So, again, when we're talking, overtime, need to be aware over 40 hours, they're getting time and a half their regular rate. And, we'll talk a little bit, there are some exemptions that can apply, but typically, and, this is just a very general statement, the seasonal help that companies are bringing in are typically not the, higher level managers and, exempt type of personnel. They're typically non-exempt, meaning they should be paid hourly. And, so companies need to understand that, keep the same documentation that they would otherwise. And if there is an exemption, certainly remember the federal and any state counterpart requirements that people meet certain duties, they're paid a certain salary. So really, the same concepts that a company would look at in terms of how to classify and how to pay their regular workers, that type of planning has to go into the onboarding process and of the seasonal workers.
So the way I think about small business owners, I mean, so many times, like I might pay my babysitter on Venmo, right, on my phone. I'm thinking, okay, this is the 17-year-old kid who watches our kids, and you know what, she's gonna come help us out for a little bit during the summer, and I'm already paying her on Venmo on my phone here. well, we'll just do X number of dollars per week or per day, and I'll just pair that same way. But not that it is even legal or appropriate with the babysitter. I mean, maybe you can take us through the minimum hour requirements. But if you're bringing someone on as a seasonal worker, even though there's not a legal classification of seasonal, if they're an employee, right? So overtime, number of hours worked, minimum wage, taxes, paying that they have to have their taxes deducted. You have to have the employer portion of taxes. You have to declare this on your quarterly 941. Can you, without trying to make everybody an FLSA expert, can you kind of take us through the core blocks that employers must think about? Because I don't want to stop at just saying, hey, you have to treat them exactly the same as all your other employees, because I think people just don't necessarily think about what those elements are. Can you just take us through the biggies at least?
Yeah, and I think maybe the biggest one, which you were pointing toward, is the maintenance of records. That, for whatever reason, like you said, employers might think, oh, I can pay this person, in cash, or I'll just, Venmo them money, or it's something other than what they would normally do, and that's simply not the case. For instance, in wage and hour audits, by the DOL, especially the federal DOL, when they conducted an audit, a wage and hour audit, they're looking at your regular employees. They're looking for a whole lot of things, but they're also looking at maybe seasonal workers, whether they're, minors, as we'll discuss in a little bit, the things that are applicable to them. But, I've had circumstances where a client has great records. They've maintained time records, clock in, clock out for employees, and payroll. But then we get to the subset of seasonal workers and we have no records. And that can be disastrous in an audit or a lawsuit, because, as I always love to say, if it's not documented, it didn't happen. So if you have these workers who, seasonal workers who are, putting in their time, working, 40, 50 hours a week, they may be entitled to overtime. And if you're not tracking their hours, that's something big. So I think maintaining records is a huge thing. Another one is wage notices. And, this isn't necessarily required under the FLSA, but many state counterparts require, some type of notice at the outset of employment that provides some information as to how the person's being paid, the rate of pay, overtime rate, day of the week they'll be paid. These are, the same onboarding documents that should be used for, seasonal workers. And, even though we're, you might think they're a little, there's a less formal relationship, you need to have these things because there can be penalties under the law for not having, these types of records.
Yeah.
So, and again, classifying workers is always important, right? If there are going to be any exemptions applied to workers where you're saying they're not entitled to overtime, that means we need a job description, right? There should, just as a company should have job descriptions for its, its regular workers, there should be a job description for these seasonal workers, so that if an exemption is challenged, we have a job description that outlines what the duties are, and they're, the real duties, not just something we put on paper. And they, it falls under an FLSA exemption, like the executive or professional exemptions. So I think all those are really important, and certainly a number of other topics we'll discuss today, I think, fall within this FLSA wage and hour context, just because there's so many, details here with seasonal workers that can really throw off an employer and, result in potential liability. And if you're bringing on a lot of seasonal workers, that can add up.
Yeah. So I guess maybe just close on this chapter here before we move on and start talking about some of the nuances. Our guidance to employers is, and this might just sound stupid, obvious, and be a bit blunt, yet you don't get to treat seasonal employees differently than regular employees, right? You still have to classify them exempt or non-exempt. You still have to follow the Fair Labor Standards Act. You still have to pay overtime. You still have to meet minimum wage requirements. You still have to pay taxes. The biggest one that gets especially small employers in trouble. You still have to pay the taxes. You still have to do I-9s and all the documentations that you would for any other employee. So I think that's kind of our baseline starting point. Is that fair to say, Brian?
Yeah, absolutely. And I love that you brought up the I-9. I think that's another one of those things that when employers are thinking, oh, this is a little less formal than normal, that they might forego that. But remember, if you get an I-9 audit, all employees, seasonal or full-time, are going to be part of that, and you'll get dinged and penalized if there's a subgroup that you're simply not applying the I-9 process to.
That's right. That's right. That's right. Okay, so let's talk about some specific nuances. Obviously there's a correlation, and it doesn't apply to all businesses, but when I think summer and I think seasonal work, the topic of interns come up. So what are the legal obligations of an employer saying, oh, I don't have to have any documentation. That's just an intern.
Right.
Get more specific for us for what's required of an employer.
Yeah, and again, just as we were discussing, right, this is another one of those intricacies that has wage and hour implications when we're talking about whether someone, an intern should be paid or unpaid. And right in the last 5-10 years, this topic has gotten a whole lot of attention under both, state and federal law. Back in 2010, the U.S. Department of Labor issued a very, I'll say, unworkable 6-factor test. And over the next several years, the federal courts really struggled with that test, and many of the Circuit Court of Appeals in the next several years started essentially drafting their own tests for whether an intern could be unpaid. And looking back at the FLSA, right, it's difficult because interestingly enough, the FLSA does not actually define who is an employee. And really here, the question is whether that intern is an employee, thus demanding, the minimum wage and overtime. So, right, the DOL and courts grappled with this for a while. And, finally, within the last couple of years, in 2018, the US DOL finally listened to the federal courts and basically issued a new test for whether an intern could be unpaid. And we call this the primary beneficiary test. No longer 6 factors, there are now 7 factors. So, yeah, but again, I'll get into it a bit, but it's really, looking at all the circumstances, and we're looking at whether the intern is the primary beneficiary of this relationship or the employer is. If the employer is the primary beneficiary, then this intern is likely an employee and they need to be paid according to all the laws. So we're talking about minimum wage, overtime, everything else. But if the intern is the primary beneficiary of the relationship, then the classification as an unpaid intern is likely allowable, and they can get their, whether it's school credit, but not necessarily getting paid. And so this test is flexible. No factor is determinative. And I won't go through all the factors, but I think a couple of the major ones are whether there's an understanding that this will be paid or unpaid, right? That should be absolutely communicated at the outset. But another thing is that this intern should not be displacing a worker, right? An unpaid intern is not filling a need of the company where you're not going to be hiring a worker, you're going to be having this unpaid intern fulfilling that role for the summer, right? That becomes very problematic.
So you can't lay off your workforce and go hire a bunch of free interns to not have any labor costs for the summer, right?
Yeah, I'd say find an attorney immediately to defend a future lawsuit if you were to do that. You know, it may work very well for the short term, but once a plaintiff's attorney finds out about that one, you're in trouble. And you know, and one of the other factors is that the experience should be similar to that of the educational environment. So you know, it, you know, a company that's employing unpaid interns, this should be a thought out, well planned program. Even if you're a small employer, right, this should involve shadowing, it should involve feedback. These unpaid interns should be sitting in on meetings, right? They're not just running and getting coffee. They're actually involved, and even if they're not doing the work, that you're exposing them to the work, almost to the point where they might be taking a little time away from the company and certain managers from doing their jobs because they're helping and the interns learn about this area of work. So really, I guess a couple tips, if I could bring it down to that for interns, would be have an agreement or some sort of acknowledgement outlining the arrangement. And again, this is really if you're having an unpaid intern. If you're having a paid internship, again, that's essentially an employee and you're going to pay them as as your others. But for unpaid interns, right, we want to have a written acknowledgement outlining the relationship. We want to ensure that they don't have a promise of employment at the end of the internship. That's actually one of the factors whether they're promised a job. Because you can imagine companies can get away with certain things in classifying some type of trainee as an unpaid intern when they're really just trying someone out for a job. That's really not what this is about. And what I would suggest is designate a mentor. There should be a mentor for each intern. There should be weekly meetings. Provide feedback both ways. The intern should be giving feedback and you should be giving the intern feedback. This should really be a learning experience. You should ensure they're shadowing certain people within the company and just generally make sure that there's a benefit of this to the intern. If the company's doing that, then you should be relatively safe with an unpaid internship. But again, I should note that, as always, look to your state laws as well. Again, this is the federal law, and I can tell you that many states, whether they explicitly state it or not, they do follow this primary beneficiary test of the USDOL. But there are a few states that have their own tests. I think New Jersey, for instance, is one that has a slightly different test. So again, federal the federal DOL, right, they always set the floor as to what we're looking at, and then states can add even more stringent requirements. So
I think it's every week we add this caveat that we generally cite federal law in this weekly discussion we have with this show because it's impossible to keep up with it in real time or even do justice to all of the state and increasingly local municipality versions of all these federal laws, right? So again, I think our guidance here is the new federal test for internship has to do with who's the primary beneficiary. If you intend on not paying this intern, then you better really have your act together and have good documentation that proves it. And just because it's the right thing to do, if you're not going to pay someone, that they need to be getting a true education out of this process, and they're the primary beneficiary. The secondary beneficiary, you are getting some free labor out of it, but they're the primary beneficiary. If you're seeing unpaid internships as a way to skirt paying taxes and labor, you are on very thin ice, and you should probably think this is just a matter of time especially in today's more litigious climate. And I think today's young worker coming up is probably more aware and self-aware of their protections than maybe any generation. That clearly we guide against that. Anything else you want to add before we start talking about not just internships but youth workers, that is such a big part of the summer employment?
Sure. And real quickly, just to pick up on the one word you said, which was protections. And so, our focus here on unpaid interns is really on the wage and hour context, but there are also all these, state and local, anti-discrimination, anti-sexual harassment laws, and many of them, if not most of them, apply equally to interns as they do to employees. And so, when you bring on interns, even if it's an unpaid intern, there's certain policies, certain documentation you want to provide, right? You want to provide an anti-harassment policy. You want to make sure that they know who to complain to if they're, being, harassed or, feel they're being discriminated against. Because many states are providing interns, those same rights as, regular employees. So, that's something to take notice of, that, interns can be victims of harassment. They can also harass or discriminate against others, right? You bring in, it's just, you think about a lot of, potentially young college age kids coming into your workforce, working together. You want to make sure they're not, harassing each other, right? That they understand how to operate in a work environment, because for many of these, kids, we'll call them, it might be their first time or one of their first times in this professional environment. And so
Right.
I think, the onboarding for the interns, explaining the culture, what's expected, and again, providing any, for instance, here in New York, we have, a lot of, we have some sexual harassment notices. Those are things that you can still provide interns to make sure that, they're not becoming a liability to the company.
Yeah. Mary Simmons was my guest on a recent show. We were talking about how to help prevent sexual harassment. And part of the employer's job is not just to deal with it when it happens, but to create an environment of protection. And that's not just for employees, that's for anybody who comes in the building. So if you got a problem with the UPS delivery person making your front desk office staff uncomfortable, it's your job to protect against that. So it's not just employees, it's contractors, it's anybody else comes in the building, and certainly interns. So, all right, anything else on interns before we move to youth workers?
Yeah, I think that covers it. Of course, each of these topics could be a full hour, if not more. But I think that that covers it, certainly.
Yeah. Okay. So what are some of the legal protections that employers need to understand around age? Where are the cutoffs? I think this is one of the most common areas where employers kind of slip up unwittingly.
Yeah, certainly. So again, seasonal workers, especially when we're talking about the summer season, we're talking about a lot of people under, minors under 18 entering the workforce, whether, they're graduating high school and have some time before college, or they're just, high schoolers who are off and for the summer. And so once again, we're looking back to the FLSA for some guidance here. And there are certain restrictions for all sorts of things regarding minors, whether it's hours of work or types of occupations they can work in, and it all depends on their age. And so when we'll start first about the type of occupations these minors can work in. And so mainly what we're looking at, the restrictions are really geared towards putting these minors in safe working conditions and, not having them work in areas or with machinery that will be, dangerous to them. And what the law does, the FLSA does, is it really separates minors into two categories. We have the 14 and 15-year-olds, and then we have the 16 and 17-year-olds. And then once they reach 18, treated just like any other adult employee. And so, and again, I mentioned this, before that, DOL audits will get into these types of seasonal workers. I can tell you specifically that the US DOL, in every wage and hour audit I've ever had with them, they include a child labor audit. Right, they're looking for any minors that are employed by that company, and if they find minors, they're looking at what the occupation they're doing, what hours they're doing. So this is at the forefront of what the DOL is looking at. Right, they want to make sure that minors, because of their the potential to for abuse of the law, that they want to make sure that companies are complying. So
can you say more about the equipment? So I'm sure there's some legal definitions, though I have to assume the lines get blurred. Obviously, you can't put a 14, 15-year-old running some big forge, right? Molten steel blowing everywhere, a dangerous job, clearly. But a cash register is also a machine. So what machines, or what maybe not asking specifically on machines, what are the criteria that determine whether this is in fact a dangerous job?
Right. So the FLSA, the good thing is they give a lot of examples of what type of jobs they deem are dangerous. I think the term they use is quote unquote particularly hazardous. And again, that leaves a lot of room for figuring it out.
Leave a particularly large amount of wiggle room. Yeah.
Yeah. But there's certain industries, there's certain types of equipment that say 16 and 17-year-olds. I mean, because when we're talking about the 16 and 17-year-olds, that's really what the restrictions are about. So we're talking about number one, they shouldn't be driving motor vehicles as part of their job, right? That's a dangerous machine. When we're talking about the food industry, they shouldn't be handling meat processors, right? Like looking at the deli, those machines can be dangerous. Baking machines, many baking machines are things that 16 and 17-year-olds, and obviously 14, 15-year-olds are not permitted to work on. And then wood cutting machines, most types of electric saws are not permissible. And then even outside of machines, if we're talking about roofing or excavation or demolition, those are all types of occupations that minors should not really be involved in. So again, there are some exceptions, especially in the food industry, if we're talking about something that's not really industrial sized equipment, but maybe a plug-in mixer or a plug-in thing like that, where it's something that you might typically find in a household kitchen as opposed to an industrial kitchen. And so I would tell employers, number one, you can refer to the FLSA. There are a lot of examples there as to what is and is not permissible. And if you don't find your particular situation, reach out to someone, because that's one where you really, both for legal purposes, liability purposes, and just for general safety purposes, you don't want to be putting minors in situations where they're likely to get injured, right? That's really what this is all about.
Brian, this is one of those things that I suspect no one ever intentionally would put their minor employee in harm's way. But I'm just thinking, like, old school employers like my dad. He would have, I grew up on a farm. He would have thrown me in what would be today considered very dangerous situations that he certainly wouldn't have thought so. So can you give maybe an example or two of an area where an employer really didn't think that they were putting their their employee in a dangerous situation, but the court saw otherwise?
Yeah. So I think the problems oftentimes come with those younger, 14 and 15-year-olds. And I've seen this one before, where having, minors even working on a ladder, right? 14 and 15-year-olds should not even be on a ladder, scaffolding, things like that. They shouldn't be working with, weed whackers or trimmers. So I've seen situations with kids in, more construction type or landscaping situations where, again, not that they got injured, but it went a bit beyond, what they should have been doing, right? They could be doing landscaping, digging with a shovel and, hauling, some amount of stuff in a wheelbarrow maybe, but you put them up on a ladder or you give them, a weed whacker, those things, again, while the employer, like your father, I mean, my father too would have me do that around the house, but when you're not, again, one of the things that I'm always telling clients is that your employees are not really your family, right? You create and foster an environment where you're all friendly, where it feels like a family, but it's not family. So
Right.
you can't just put these people in these minors in situations that you'd be fine putting your kids in. There are these restrictions. But again, like you said, cashier, being a cashier, that's fine. Bagging and carrying stuff, that's fine for these types of, 14, 15-year-olds. Obviously, office and clerical work, there is an exception. Obviously, office machines are fine. We're not going to restrict, a 15-year-old from, scanning and copying. That's a big machine, but at least as far as I've seen, not causing, very, very much harm.
Right. Should we just say this, that our guidance here would be, um, knowing that there is kind of definitionally a bunch of gray area here, just use our best judgment and not put 14 and 15-year-olds, can't work under 14 and 15-year-olds on the more dangerous jobs, and use common sense. A court is probably going to look at what reasonableness you did as an employer to protect that employee. Is that just a fair, simple way to look at it?
Yeah, exactly. I think you're right. It all starts with common sense, and that general concept that you're going to treat minors differently than you would treat adults. And
Right.
so if you come into it with that mindset, that should get you pretty far in determining, what really should or should not be done by these types of employees.
And so we talked about dangerous equipment or the dangerous job, but what about hours worked for a 14, 15-year-old versus a 16 or 17-year-old versus
Right.
8?
Yeah. So, under the FLSA, interestingly enough, there are no restrictions on hours for those 16 and 17-year-olds. The restrictions are really only for 14 and 15-year-olds. Again, caveat, look to your state law, of course. But, for, 14 and 15-year-olds, again, the hours that they can work depend on whether school is in session or not, or whether that the work is performed, for instance, the day before they're going to school or not. And so I believe on a weekday, 14 and 15-year-olds, or on a school day rather, they can't work more than 3 hours. But now that school's almost out, once we get into the summer, they can work up to 8 hours a day and up to 40 hours a week when school is not in session. So there is a big difference once school lets out. But one thing I would note is you should probably ask your minors, these 14 and 15-year-olds, find out if they're in summer school. That can impact this. If they are in summer school, then we're talking about those school in session restrictions. and they don't quite have the same flexibility. Another issue that I see come up and that I've had clients get dinged on with the DOL is that even if you're not scheduling these 14 and 15-year-olds for an unreasonable amount of time, right? We all have employees call out sick. We're in the midst of the pandemic, or maybe not, but there are people who are going to be sick and calling out. You need to understand that if you have a minor filling in for other employees, that goes to those hours. And so whoever is managing the scheduling needs to have this understanding of what restrictions, what's the maximum amount of hours that these 14 and 15-year-olds can work, because even if you schedule them correctly, if they take a shift from a colleague, that could put them over the 40 hours, and then you're running into a violation.
I think maybe the one point I'd want to maybe guide, especially small businesses, maybe not so much medium-sized. If you're a business that regularly hires, you're in a service business, a golf course, restaurant, you're in an amusement park, so you always have this big influx of seasonal employees. Most of those folks probably know the laws. They know what they can, what they can't do, how to work with all that. I think to me the big risk here is for the small business who is not knowledgeable in all the laws around this topic, and you are bringing one employee or two employees here or there as that seasonal help. These are the people that I think especially pay attention. Look at your local and your state laws, not just the federal laws, because the younger generation coming into the workforce is more aware of their legal protections than said before than any generation before, and if they feel slighted, they're also much more likely to report than any generation before, whether they feel sexually harassed or discriminated against, or that it's unfair that you're making them work X number of hours or on such and such machine. Any other guidance you want to give around these age breaks, 14, 15 versus 16, 17-year-olds, before we move on to our next topic of benefits?
Yeah, and I think without going into it, I would just say that look to your state law for other things like meal breaks and rest periods. Those aren't governed by federal law necessarily, but most state laws have requirements for adult employees for rest periods, and I think at least half the states have something on the books for rest periods for minors. So that's something to understand. One other issue is work permits. Some states require employees of certain ages to have work permits. It might depend on what time of year they're working. So again, these are certain things that most of the time, look, your state labor department should have this information, but if not, reach out to Assure. They can guide you on these, because you want to make sure that you're following the law, especially when it comes to minors, and not being overly demanding of them, or and then one other issue I would say is that be careful on entering into agreements with minors, like an employment contract, an arbitration agreement, even a background check. Minors under 18 cannot consent to these types of things under the law. You very well might need a parent to, for instance, consent to a background check. So just be careful on some of those issues as well.
Yeah, very good. Okay, let's move on to health benefits. I think most people understand the legal requirement. So maybe just at a high level first, forget seasonal. When are you obligated to provide health benefits? When are you not? So Affordable Care Act says more than 25 or more employees you have to provide health care. but there are still some rules around part-time versus full-time, and the line is 30 hours a week. There are rules for that. Can you just speak to 60 seconds, Brian, of what, forget seasonal, when are you required to supply benefits? Because I think going back to where we started, you have to treat all employees the same because there's not a legal definition of seasonal. Am I setting that up correctly?
Right. Yeah, I think so. And so, right, we're all right. We're always looking at whether a company has the sufficient number of full-time employees or full-time equivalents to hit certain mandates. And we're looking at how to measure those, whether it's the monthly or look back periods. So those are certainly things that companies should be looking at all the time. And really, one of the common questions I have from employers in this regard is, can I treat different employees differently? Can I offer health benefits to some subset of workers but not to others, right? Whether it's say I want to offer it to management but not the laborers. And there's unfortunately there's no easy answer to many of these questions. The Affordable Care Act is a bit complicated, but one of the things certainly in offering benefits maybe to different types of employees is avoiding any discrimination issues, avoiding any disparate impact, right? If we're going to provide benefits to our managers but not to our laborers, are our managers predominantly one race, and our laborers predominantly certain other races, that while we don't have the intent of discriminating, that the result is that we're giving benefits essentially on race lines. So yeah, there's just so many considerations that go into it. But I guess working this back toward the seasonal aspect, right, there's generally not a requirement, and I say generally, not a requirement to provide health insurance to seasonal employees. But we need to keep in mind, in measuring the full-time equivalents for the ACA's requirements, that can actually impact this analysis. And depending on how a company looks at it, could result in the company having to provide coverage. So for instance, right, if the company uses the monthly measurement of full times, right, you're looking at, for instance, I believe you're looking at the past month to see workers who worked at least 30 hours a week. And or right, well, we want to see workers who work 30 hours a week, and so we're looking at who worked over 130 hours or so that prior month. If you're doing this monthly measurement, that could result in the next month having to provide coverage to certain seasonal employees who may have hit that threshold. And that's something to be aware of, because many companies just assume, right, no matter what, there's no requirement to provide these seasonal workers coverage. That said, if companies use the alternative look back method, which you're taking some defined period, looking back at that, looking at an average to see whether the employees worked at least 30 hours a week, in that method, you're likely not going to be triggering coverage requirement for any seasonal workers, because depending on that sample size, that look back period, those seasonal workers wouldn't have met the hours threshold. So
Brian, would I be saying it right then? Okay, local and state governments can have whatever laws they want that are above and beyond. But I think I said 25 employees, it's 50 employees for the Affordable Care Act. But the real, from a federal perspective, the governing rules here are really around ACA, Affordable Care Act, right? And which method you're using to determine and calculate benefit eligibility or benefit requirement, I should say. And it really kind of sort of has nothing to do with seasonal. It's all about the model you're using to calculate part-time versus full-time by the rules of the ACA. Is that right?
Yeah, I think that sums it up perfectly. Yeah.
Yeah. So to maybe to put a bow on this one, then it's you cannot think as an employer, you cannot treat quote unquote seasonal employees different than other employees when it comes to providing benefits. You are obligated under the law being the Affordable Care Act, the ACA, to provide your employees with benefits or not provide them with benefits based on those requirements, not whether they are in fact seasonal. Right?
Exactly. Yes.
Okay, let's talk about then this maybe I don't know that people get in such trouble around minimum wage as maybe they used to, but I sure think people get in a lot of trouble around overtime. And it's for the same reasons we've been discussing, right? You don't get to say, hey, seasonal help, you know, we're a little bit lumpy, so you didn't work that many hours for last week. You worked a bunch more this week. It was just 80 hours. It was under 80 hours for the 2-week period, so no overtime. But that's not how the law works, right? So in the eyes of the law, what must employers do when it comes to paying overtime? And I think it's maybe more obvious how to handle minimum wage.
Right. So, right, overtime, right, we're tracking their number of hours, and if they hit over 40 in a week, that triggers, you know, time and a half. And like you mentioned, you know, many employers have some misconception that, you know, they can use flex time, that, you know, all right, you hit 50 hours this week, so you'll work 30 next week, no overtime. You know, that's not how it's done. The overtime measurement is done, you know, on a week by week basis. You know, so I mean, you know, for instance, you could have an employee who, you know, is scheduled to work 40 hours a week, and they work, you know, 10 hours on Monday. So you might have them work, you know, 6 hours on Tuesday. You can flex within the week. And that can be done for seasonal workers, just like, you know, full-time workers, where you can flex within that week, you know, to change their schedule to, you know, ensure they stay under 40, but not between weeks. And I think, you know, one area that I see a lot of employers trying to get creative with in this area with seasonal workers is classifying them as independent contractors. And, you know, thinking that, well, they're an independent contractor, that means I can pay them however I want. There's no overtime. And, you know, many employers aren't necessarily understanding there's a test, right? There's a test to see whether the employee is an independent contractor or an employee. And again, we're talking about, you know, most of the time there's going to be a state specific test that your state uses, but there are a few general concepts around, you know, independent contractors and, you know, avoiding these overtime requirements. You know, we're really talking about people who the company does not control. That, right? You're telling, you know, an individual, this is what I want done. This is what we need done. And then that individual controls, you know, the process and how it gets done. They're often working, you know, with their own equipment. There's some opportunity for loss, for profit or loss for the independent contractor. They're not just getting a salary regardless of what they do. So I would suggest that, you know, if you're considering labeling some of your seasonal workers independent contractors, you know, be very careful about that. You know, there are some pretty penal consequences there, you know, whether it's going to be, as we're talking about now, unpaid overtime because you've paid them in a way that doesn't comply with the FLSA or your state equivalent. But there's also, you know, unemployment insurance contributions, workers' comp. You know, so there are other issues that, you know, that will stem from a misclassification when, you know, the company is just thinking, you know, how can we lower our, you know, overtime hit, you know, with these seasonal workers.
Right.
So, and again, I understand, you know, one thing that clients come to me all the time right now, even in this market where, in this market right now is I can't get enough employees. And so I have to schedule the employees I have for, 50, 60 hours. And, I understand that employers are looking for creative ways to reduce those labor costs.
Right.
But, obviously hiring more employees and keeping them all below 40 is one way to do that. That's simply not possible all the time, but be very careful if you're then, looking to, label them as independent contractors to avoid that overtime requirement.
And Brian, that overtime, this is an area where we see a lot of movement legislatively with the states, right? So California and several other states have their own overtime laws that layer on top of FLSA at the federal level. So, in your example, you only worked 2 hours on Monday. So maybe I'll stack them up with a bunch of extra hours on Tuesday, but I'll keep them under my 40 for the week. Make sure you're in alignment with local in state law as you make those decisions as well.
Right. In California, that might not do the trick when overtime can be triggered, I think, by working over 8 hours in a day. So yeah,
right.
Certainly.
That's right. That's right. And for an employer who might be thinking, you know what, I'll risk it. If it results in, and you might not ever get caught, right? But if it does, you have a situation, especially with a seasonal worker who feels slighted or wronged, and they report you, and there is a state or federal DOL audit, wage and hour audit, they're not going to audit whether you paid that employee fairly. They're going to look at all of your records going back probably years. And however much they determine you didn't pay people properly, you're going to retroactively pay all of it and some fines. Am I saying that right, Brian?
Yeah. So right. Often these misclassifications go beyond that one, employee. I can tell you, that's the most disastrous part about this. That right, you bring in 10 seasonal workers, you've misclassified all of them. One of them makes a complaint to the DOL. They're not just looking at that one; they're looking at all of those, and they're going to look at the rest of your workforce too. So yeah, that's certainly an issue when you have multiple people in the same classification.
And I think I'm an entrepreneur. I grew up around businesses. I'm partners in businesses. Most entrepreneurs are not out there trying to screw their employees over, right? I mean, people try to do the right thing. But if you're an expert in landscaping or home remodeling or architecture, you're not an expert in tax law and HR law, right? And so people make mistakes unwittingly, and it's the really expensive thing that can happen here is that auditor's probably not going to, it's not worth their time. It sounds terrible to say it that way. It's not cost effective of their time. That's a better way to say it, for an auditor to come in and say, oh, John Doe complained about this, I'm going to examine John Doe's records and nothing else. Once they've got your books, they've got your books, right?
Yeah.
And that's where it starts getting real expensive accidentally for the employer who didn't make any mistake on, who didn't do any of this maliciously, right?
Right. Exactly.
Okay. Let's tackle our last one here. Looking at the clock, Brian, let's talk about time off requests and how does we've already established there's not a legal classification called seasonal employee. So therefore, how should employers be thinking about leave requests?
Sure. So, typically, outside of, the growing patchwork of, paid sick leave and safe time laws, at the local and state level, generally a company's PTO policies are up to them. You put them in writing. That's typically the one thing we recommend, and apply them consistently. But it is entirely okay to have more stringent PTO policies for seasonal workers than you have for the rest of your workforce. We just want those to be communicated at the outset, right? If you have someone coming on for 2 or 3 months, understandably, we're not giving them 5 days off during that time. So it's okay to have your own PTO policies, limit the time off available. But like I mentioned, there are paid sick time laws at the local and state level for many employers to consider. You know, most of these laws apply equally to seasonal workers as they do to year-round workers.
Yeah.
However, what often is the case is that they have waiting periods. So, you know, many of these laws have, 60 or 90 days or even 120 days before an employee can use the PTO they've accrued. So even though seasonal workers may accrue this PTO, be aware that you still might not need to give them the time off. Of course, if you have the same seasonal workers coming back, summer after summer, check your local law as to how that will impact, because if they accrued some time off the previous summer but couldn't use it because they hadn't been worked past that waiting period, check your local law, because the following summer that might still be in their bank and they might be able to use it then. So those are certain things to be aware of. But otherwise, again, generally we want to onboard seasonal workers the same way we onboard our regular workers. We want to give them our policies. We want to ensure they know what the expectations are, both with respect to time off and other policies. And just from an employee relations aspect and setting the company culture, right? We don't want to bring this whole workforce in for the summer season that either is inconsistent with what the company's done, with all their full-time workers. You want to make sure that they understand the company culture, they understand what's expected of them. So again, I think the one law we can pretty safely say does not apply to seasonal workers in this context is the FMLA, and that's mainly because to be an eligible employee under the FMLA, you need to work 12 months or 1,250 hours. So seasonal workers won't hit that, but certainly employers need to be aware of their local laws on paid sick time.
Brian, I think you brought it home perfectly. So our guidance to employers is many of you have and utilize seasonal employees. They just whether it's a new available labor pool for you or the nature of your business because you're in a seasonal industry. So many of us deal with this. The piece of guidance would be know your laws. We are, Brian has shared here some of the federal requirements, a lot of it around FLSA, but increasingly, like the way you described it, there's a patchwork of local and state laws that is ever evolving to be aware of as well. And I think just the biggest, most practical advice we could give is there's no such thing as a seasonal employees in the eyes of the law. There are just laws. So if it's the Affordable Care Act, there aren't seasonal employees, there are just employees, and you have to apply your test to see whatever methodology you're using to determine full-time equivalency, whether you must provide benefits or not. You simply have to follow the Fair Labor Standards Act for paying overtime. You don't get to pay the person in Venmo without on your phone just because they're a kid in your eyes. You still have to pull payroll taxes out of that compensation for them, and you have to pay the employer taxes and get a 9-9 and file your quarterly tax returns. So you have to treat seasonal employees within the eyes of the law just like you would any other employee. So with that, this is what Assure is here for. So increasingly, this patchwork of laws is harder and harder to get your head around. And most small business owners are experts in their industry. They're not experts at HR. And so the problem is, from a cash flow perspective, hiring a Society of Human Resource Management, a SHRM certified HR professional could easily cost you at least 70, 80, 90, 100,000 or more to hire a full-time staff member. So for pennies on the dollar, Assure offers different programs that are flexible to meet your needs, whether it's writing handbooks and providing sexual harassment training, or we can actually become your entire HR department where your employees literally call us and we are your fractional HR department virtually and at a fraction of the cost of what it would take to build that in-house. So if there's any way we can help, we'd love to. Let us know. Maybe Brian, can you just spend 30 seconds telling everybody about who Jackson Lewis is and how you guys help clients?
Sure. So Jackson Lewis, we're a labor and employment defense firm with a nationwide footprint with over 60 offices throughout the U.S. We provide, like myself, often litigation defense against all sorts of employment claims, but also ranges from advice to counsel to all sorts of legal needs that touch on the employer-employee relationship.
Brian, I always enjoy talking to you. I learn something every time. Thanks to everyone for joining us. If there's any way we can help our anyone in our family of 80,000 plus growing small and mid-sized companies with payroll or human resources, by all means, let us know. And until next week, thank you for your time. Thanks, Brian.
Thank you.